All right, y'all, welcome back to Anti-War Radio. It's Chaos 92.7 in Austin, streaming live worldwide on the internet at chaosradioaustin.org and at antiwar.com/radio. And our guest today is Grant F. Smith from the Institute for Research, Middle Eastern Policy, otherwise known as IRMEP, I think. And he's the author of the book America's Defense Line, the Justice Department's Battle to Register the Israel Lobby as Agents of a Foreign Government. Welcome to the show, Grant.
Hi, Scott. It's great to be here. Thanks for having me on.
Well, it's good to have you here, and we've run quite a few of your articles at antiwar.com. Obviously, the case that we're going to be discussing today, the supposed-to-be trial of Steve Rosen and Keith Weissman from the American-Israeli Public Affairs Committee, is a story very important to all of us at antiwar.com, and yet it frankly is the kind of thing that's caught up in all these legal maneuverings back and forth and motions to dismiss this and motions to appeal that.
Yeah.
And I don't think any of us on staff at Anti-War are lawyers. It's kind of gotten a bit past us, but I know that now it's at the federal appeals court level. There's something that's being appealed up there, and I know that you've written an amicus brief for the court to consider while making their decision. So
right.
I guess if you could just sort of let's go back first of all to 2004.
Okay.
And what happened with the arrest of Steve Rosen and Keith Weissman. Who are these guys? Why'd they get arrested? And then why were they on trial in the first place? Then maybe we can fast forward to where we're at now with the case.
Sure. Well, first of all, let's not leave out Colonel Lawrence Franklin, who was also arrested and indicted. And what was happening basically was the AIPAC officials, in this case in charge of policy development and all sorts of initiatives at AIPAC's headquarters here in Washington, had contacted and begun kind of running Colonel Lawrence Franklin to get information that would help them in influencing U.S. policy toward Iran, which AIPAC appears to favor a hard line, including up to at least a couple of weeks ago, even legislating acts which many observers have considered to be acts of war, blockades, financially blocking Iran and doing all sorts of escalatory activities. But
as Pat Buchanan once said, the Congress is Israeli-occupied territory.
Right, and basically in this case, they were acting on behalf of AIPAC to funnel that information to Israeli officials. This was information in presidential directives, which Lawrence Franklin, being part of Doug Feith's team over at the Pentagon, had access to the development of, and carving out a role for AIPAC to be operating at that executive level. Franklin had said earlier that he wanted a slot on the National Security Council, that he was concerned about U.S.-Iran policy. He was trying to present those to AIPAC as a way to increase his own career trajectory. The AIPAC officials, in this case, made a lot of strange diversionary activities when they're actually receiving briefings orally from Colonel Lawrence Franklin in various restaurants at public locations in D.C. And so basically the government had flipped Franklin, turned him into their asset, and collected all sorts of wiretap information, etc., to then indict the two AIPAC officials. There was a lot of evidence that they were actually trying to indict the entire organization, which would have led to its immediate collapse if that had gone through, just like Enron or Arthur Andersen or any corporation that suddenly faces a huge blow to their entire credibility and kind of pierces the corporate veil in that case. But
all right, wait. Let me stop you right there. Who was it that was going after an indictment of the whole place? The FBI or the U.S. Attorney's Office? Or
well, the FBI. There was a notice between some of the defense attorneys saying that the lead prosecutor was putting a leash on the FBI not to go after the entire organization. This was McNulty, who subsequently rose to become a much higher-level DOJ official after successfully petitioning not to expand, and these are the words within the correspondence in the court docket, not to expand but limit the prosecution to Stephen Rosen and Keith Weissman, as opposed to either more individuals or the entire organization.
All right, so what we have here, we have Larry Franklin. He's an Iran analyst inside the policy department at the Pentagon.
Right.
He's got designs on moving up to the National Security Council. He wants to go work for Stephen Hadley at the White House, I guess.
Right.
And he makes a deal with the Israel lobby that he'll give them information if they can get him a better job in the U.S. government.
That's the basic appearance. Plus, he also had tons of classified information stored at his home, which I believe was in Virginia, which really compromised him. So he not only made this ill-fated career move, but also severely compromised himself by having that classified information. The rare thing, the unusual thing is, although he is subsequently been found guilty or pleaded guilty to do about 12 years and pay a $10,000 fine, he's still out there. He has not yet gone to prison. He's not reported to prison. And observing this entire trial, it looks kind of like special treatment, although, of course, the government wishes to use him as a witness for the prosecution. What happened back in the 1960s, and we've written about this, I think this is the last anti-war article I did, talks about the American Zionist Council, which was an organization that was receiving millions and millions of dollars of Israeli funds and using it to lobby Capitol Hill and Congress. There were open Senate hearings about this in 1963. In 1962, secretly, the Justice Department actually ordered this organization to register as the foreign agent of Israel, and then began this long process, a behind-the-scenes battle with the American Zionist Council to actually force them to openly disclose all of their activities. The short story is that basically after a similar 3-year period that we're seeing repeated in this trial, that process was shut down and short-circuited, and the AZC was allowed to make a secret filing in which they didn't disclose any of the names or organizations that had been lobbying and doing public relations. They also didn't have to file for any more than a 3-month period as opposed to the entire 2-year period that was investigated in the Senate. And then the Department of Justice acquiesced to making the entire thing classified so that nobody could even have seen it until it was declassified, and we did that in June 10th of 2008. So our points with this recent trial is that, again, we're not supporting the government, we're not supporting the defendants, we're simply saying the American people has never had a chance for an open process to actually sort out some of these issues. And we allege, basically, it's hard to even imagine that AIPAC officials would be under indictment for espionage if they had been properly regulated back in the 60s or earlier, as what they essentially are, which is a lobby for a foreign government.
Well, now on the other hand, if you're the judge, you don't go on and continue a trial that ought to not continue because the American people would like to hear about these issues. I mean, we're talking about 2 individual men's lives at stake here, right?
Yes, we are. But let's consider some of the extraordinary bending over backward right that the ruling judge T.S. Ellis has attempted to inject and which are being appealed. He's essentially said in this case, and maybe we can hash this out a little bit, that the 1917 Espionage Act, which prohibits any American from relaying classified national defense information that could be used to the injury of the United States or to the aid of a foreign nation, he's saying that the government prosecutors who are attempting to move this to trial now have to, and he added this unilaterally, this is not in the law, that they've got to prove that they actually knew it would be used to the harm of the United States. They have to now prove some state of mind that they knew the information was classified. They have to now show some intentions. They're going to have to basically prove, if this goes through and is not properly challenged, that it could arrive to the point that the U.S. and Israel don't have similar interests. And so they're going to be now forced to prove some things that are far beyond the Espionage Act guidelines. The other thing that they're protesting as well is Classified Information Procedures Act. The government basically says, we want to prove that they attempted to obtain classified information and then funneled it to all these parties that shouldn't have gotten it. The defendants are saying, hey, we've got to spread around this classified information. Everyone's got to see it because, number one, it wasn't even classified, and number two, we have a right to this information to prepare for our defense. So this, back in 1982, when this SIPA was actually created, it was created to prevent people like Colonel Oliver North and others from gray-mailing the government and saying, well, you can't really prosecute me because I got to see all this classified information that you're desperate to keep secret, which actually is relevant national security information. You can't present that. You can't have that be secret anymore. I've got to present all of that in court.
So we're already a couple of minutes over time here. I got to let you go, but I really appreciate your time on the show today.
All right, Scott. Thanks a lot.
All right, everybody, that's Grant F. Smith from the Institute for Research Middle East Policy. The book is America's Defense Line, the Justice Department's Battle to Register the Israel Lobby as Agents of a Foreign Government.